All right, everybody. Happy St. Patty's Day to everyone out there in TV land. Oh, I didn't even cue the music up. Let me cue the music up real quick here. The Happy St. Patty's Day regardless. But here we go. All right, everything's a bit out of sorts because everything's all fucked up since I got back from the spring break we just had. So everything's all a bit fuckered up. So that's okay though. We'll still have fun. We'll still learn stuff. So today we're doing conflicts of laws. We're doing purposeful availment of jurisdiction. We have a very famous case that all those who've been to law school or are going to law school will know. Worldwide Volkswagen Corporation, Worldwide Volkswagen Corp versus Woodson, a 1980 case that has to do with purposeful availment of a specific jurisdiction. Just realized I don't have my highlighters. Hang on. So much. All right, got my highlighter. Okay now. All right. So 1980 case. Joseph White delivered the opinion of the court. The issue before us is whether, consistent with the Due Process Clause of the 14th Amendment, an Oklahoma court may exercise its in personam jurisdiction over a non-resident automobile retailer and its wholesale distributor in a products liability action, when the defendant's only connection with Oklahoma is the fact that an automobile sold in New York to New York residents became involved in an accident in Oklahoma. 1. Respondents Harry and Kay Robinson purchased a new Audi automobile from petitioner Seaway Volkswagen Incorporated, Seaway, in Massena, New York, in 1976. The following year, the Robinson family, who resided in New York, left that state for a new home in Arizona. As they passed through the state of Oklahoma, another car struck their Audi in the rear, causing a fire which severely burned Kay Robinson and her 2 children. The Robinsons subsequently brought a products liability action in the district court for Creek County, Oklahoma, claiming that their injuries resulted from defective design and placement of the Audi's gas tank and fuel system. They joined as defendants the automobile manufacturer Audi NSU Auto Union Optinglassesklaft, Audi, its importer, the Volkswagen of America Incorporation, and its regional distributor, petitioner Worldwide Volkswagen Corporation, and its retail dealer, petitioner Seaway, and Worldwide entered special appearances, claiming that Oklahoma's exercise of jurisdiction over them would offend the limitations on the state's jurisdiction imposed by the Due Process Clause of the 14th Amendment. The facts presented to the district court showed that Worldwide is incorporated and has its business office in New York. Its distributors, vehicle parts, and accessories under contract with Volkswagen to retail dealers in New York, New Jersey, and Connecticut. Seaway, one of those retail dealers, is incorporated and has its place of business in New York. Insofar as the record reveals, Seaway and Worldwide are fully independent corporations whose relations with each other and with Volkswagen and Audi are contractual only. Respondents adduced no evidence that either Worldwide or Seaway does any business whatsoever in Oklahoma, does not ship or sell its products to that state, or has any agreement to receive, process there, or purchase advertisements in any media calculated to reach Oklahoma. In fact, as respondents' counsel conceded at oral argument, there was no showing that any automobile sold by Worldwide or Seaway had ever entered Oklahoma, with a single exception being the vehicle in the instant case. Despite the apparent paucity of contacts between petitioners and Oklahoma, the district court rejected their constitutional claim and reaffirmed the ruling that denying petitioners' motion for reconsideration. Petitioners sought a writ of prohibition in the Supreme Court of Oklahoma to restrain the district judge and respondent Charles C. Woodson from exercising in personam jurisdiction over them. They renewed their contention that because they had no minimal contacts with the state of Oklahoma, the actions of the district judge were in violation of their rights under the Due Process Clause. The Supreme Court of Oklahoma held that impersonal jurisdiction over petitioners was authorized by Oklahoma's long-arm statute, which is Oklahoma Statute Title 12, Section 1701.3A4, and permitted by the United States Constitution. The court's rationale was contained in the following paragraph, quote, "In the case before us, the product being sold and distributed by the petitioners is by its very design and purpose so mobile that petitioners can foresee its possible use in Oklahoma. This is especially true of the distributor who had its exclusive right to distribute such automobiles in New York, New Jersey, and Connecticut. The evidence presented below demonstrated that goods sold and distributed by the petitioners were used in the state of Oklahoma, and under the facts, we believe it to be reasonable insofar as given the retail value of the automobile and the petitioners derive substantial income from automobiles, which from time to time are maybe used in the state of Oklahoma. This being the case, we hold that under the facts presented, the trial court was justified in concluding that the petitioners derived substantial revenue from goods used or consumed within the state of Oklahoma. We grant certiorari and consider an important constitutional question whether to respect the state court's jurisdictional grant or resolve a conflict between the Supreme Court of Oklahoma and the highest courts of at least 4 other states. We reverse. So they're reversing Oklahoma's jurisdictional grant. 2. As long has been settled, and as we reaffirm today, a state court may exercise personal jurisdiction over a non-resident defendant only so long as there exists minimum contacts between the defendant and the forum state. International Shoe versus Washington is where this comes from. The concept of minimum contacts, in turn, can be seen to perform 2 related but distinguishable functions. It provides the defendants and protects them against the burdens of litigation in a distant or inconvenient forum, and it acts to ensure that the states, through their courts, do not reach out beyond the limits imposed on them by their statutes and status as co-equal sovereigns in a federal system. The protection against inconvenient litigations is typically described in terms of reasonableness or of fairness. We have said that the defendant contacts with the forum state must be such that the maintenance of the suit does not offend traditional notions of fair play and or substantial justice, quoting from International Shoe decision, which quotes from the previous case, Milken and Meyer. The relationship between the defendant and the forum must be such that it is reasonable to require the corporation to defend the particular suit which is brought therein. Implicit in this emphasis of reasonableness is the understanding that the burden on the defendant, while always a primary concern, will be an appropriate case considered in light of other relevant factors, including the forum state's interest in adjudicating the dispute, quoting from McGee versus International Life Insurance Company. The plaintiff's interest in obtaining convenient and effective relief, quoting from Kulko, at least when that interest is not adequately protected by the plaintiff's power to choose the forum, quoting from Schaefer. The interstate judicial system's interest in obtaining the most efficient resolution of controversies and the shared interest of the several states in furthering fundamental substantive social policies, quoting from Kulko, therefore the limits imposed upon state jurisdiction by the Due Process Clause and its role as guarantor against inconvenient litigation have been substantially relaxed over the years, as they noted in McGee. This trend is largely attributed to a fundamental transformation of the American economy, quoting from McGee. Today, many commercial transactions touch 2 or more states and may involve parties separated by the full continent. With this increasing nationalization of commerce has come great increase in the amount of business conducted by mail and across state lines. At the same time, modern transportation and communication have made it less burdensome for a party sued to defend himself in a state where he engages with economic activity. The historical developments noted by McGee, of course, have only accelerated in the generations since the case was decided. And McGee was a 1946 case. Nevertheless, we have never accepted the proposition that state lines are irrelevant for jurisdictional purposes, nor can we remain faithful to the principles of interstate federalism embodied in the Constitution. The economic independence of the states was foreseen and desired by the framers of the Constitution. In the Commerce Clause, they provided that the nation was to be a common market and a, quote, free trade unit. in which the states are debarred from acting as separate economic entities. But the framers also intended that the states retain many essential attributes of sovereignty, including, in particular, the sovereign power to try causes in their courts. The sovereignty of each state, in turn, implied a limitation on the sovereignty of each of its other sister states, a limitation expressed or implicit in both the original scheme of the Constitution and the 14th Amendment to the Constitution. Thus, the Due Process Clause, quote, does not contemplate that a state may make binding a judgment in personam against an individual or corporate defendant with which the state has no contacts, no ties, or no relations, quoting from International Shoe. Even if the defendant would suffer minimal or no inconvenience from being forced to litigate before the tribunals of another state, even if the forum state has a strong interest in applying its law to the controversy, and even if the forum state is the most convenient location for litigation, the Due Process Clause, acting as an instrument of interstate federalism, may sometimes act to divest a state of its power to render valid a judgment. Quoting from Hansen versus Denkula. Part 3. Applying these principles to the case at hand, we find, in the record before us, a total absence of those affiliating circumstances that are a necessary predicate to any exercise of interstate jurisdiction. Petitioners carry on no activity whatsoever in Oklahoma. They close no sales, and they perform no services in Oklahoma. They avail themselves of none of the privileges and benefits of Oklahoma law. They solicit no business there, either through salespersons or through advertising reasonably calculated to reach the state of Oklahoma. Nor does the record show that they regularly sell cars at wholesale or at retail to Oklahoma customers or to residents that are there either indirectly or directly, through others, or who seek to serve Oklahoma markets. In short, respondents seek to base jurisdiction on one isolated occurrence, and whatever inferences can be drawn therefrom. The fortuitous circumstances that a single Audi automobile sold to New York people in New York happens to have suffered an accident while passing through the state of Oklahoma. It is argued, however, that because an automobile is mobile by its very definition and purpose, it is foreseeable that the Robinsons' Audi would and could cause injury in Oklahoma. Yet foreseeability alone has never been sufficient benchmark for personal jurisdiction under any Due Process Clause analysis. In Kulko versus Superior Court, it is surely foreseeable that a divorced wife might move to California from New York, so that the domicile of marriage and the minor daughter would maybe live with the mother. Yet we held that California could not exercise its jurisdiction in a child support action over the former husband who had remained in New York the entire time. If foreseeability was the criterion, a local California tire retailer could be forced to defend in Pennsylvania when a blowout occurs there. And that's a case actually called Argland Mills versus Cohoes Fiber Mills Incorporated, where a Wisconsin seller of a defective automobile jack could be hailed before a distant court for damage caused in New Jersey, or a Florida soft drink concessionary, a soft drink vendor, a guy who pours soda pops, right, could be summoned to Alaska to account for injuries that happened there because a soft drink machine exploded. Every seller of chattels would in effect appoint the chattel as his agent for service of process. So a chattel is a thing you're selling. So if I sell you a Coke that's made in Georgia at Coca-Cola and you open it in Alaska, apparently by selling you a Coke that's sold to you in Alaska, I would be making myself liable to be sued in Alaska, even though I've never been there. Right? His amenability to suit would be travel with the chattel. We recently abandoned this outworn rule in Harris v. Balk with the interest of a creditor in a debt could be extinguished or otherwise affected by any state having transitory jurisdiction over the debtor. In Schaefer v. Hetner, having ensured the mechanical rule that a creditor's amenability to a quasi-in rem action travels with his debtor, we are unwilling to endorse an analogous principle in the present case. This is not to say, of course, that foreseeability is wholly irrelevant, but the foreseeability that is critical to due process analysis is not the mere likelihood that a product will somehow, someday, find its way into the forum state. Rather, it is that the defendant's conduct and connection with the forum state are such that he should reasonably anticipate being hailed there to defend his case. The Due Process Clause, by ensuring the orderly administration of laws, gives a degree of predictability to the legal system that allows potential defendants to structure their primary conduct with some minimum assurance as to where the conduct will and will not render them liable to be sued. When a corporation, quote, purposefully avails itself of the privilege of conducting activities within a forum state, end quote, it has clear notice that it is subject to being sued there, and can act to alleviate the risk of burdensome litigation by procuring insurance and passing the expected cost on to customers or consumers, or if the risks are too great, by severing all its connection with the state and not selling anything there at all. Hence, if the sale of a product of a manufacturer or distributor such as Audi or Volkswagen is not simply an isolated occurrence, but arises from efforts of the manufacturers or distributors to serve directly or indirectly and market its products in that or other states, it is not unreasonable to subject it to suit in any of those states if it allegedly defective merchandise has been there and has been the source of injury to the owners or to others. The forum state does not exceed its powers under the Due Process Clause to assert personal jurisdiction over a corporation that delivers its product into the stream of commerce with the expectation that it will be purchased by consumers in the forum state. Compare that with Gray versus American Radiator Standard Supply Sanitary Corporation case. But there is no such or similar basis for Oklahoma jurisdiction over Worldwide Volkswagen or Seaway in this case. Seaway sales are made in Manassas, New York, period. New York Worldwide Volkswagens, market, although it is substantially larger, is limited to dealers in New York, New Jersey, and Connecticut, and that's it. There's no evidence or any record whatsoever that any automobile distributed by Worldwide are sold to retail customers outside of the tri-state area, tri-state being Connecticut, New York, and New Jersey. Right, that's it. It is foreseeable that the purchasers of automobiles sold by Worldwide and Seaway may be taking them to Oklahoma, but the unilateral, meaning the only activity of the people who purchased them who claim some relationship with a non-resident defendant cannot satisfy the requirements of substantial contacts with the forum state of Oklahoma in this case. In a variant on the previous argument, it is contended that jurisdiction can be supported by the fact that petitioners can earn substantial revenue from goods that are someday to be used in Oklahoma. The Oklahoma Supreme Court found so by drawing the inference that because automobiles sold by petitioners had once been used in Oklahoma, others might also one day use them in Oklahoma as well. While this inference seems less compelling on the facts than in the instant case, we need not question the court's factual findings in order to reject its stupid reasoning. They don't say stupid, but I say stupid. This argument seems to make the point that the purchase of automobiles in New York, from which the petitioners earn revenue, would not occur but for the fact that automobiles are capable of use in any and numerous distant states, like Oklahoma. Respondents observed that the very purpose of an automobile is to travel, and the travel of automobiles sold by petitioners is facilitated by an extensive chain of Volkswagen service centers throughout the country, including some Volkswagen service centers that exist in Oklahoma. However, financial benefits accruing to the defendant from a collateral relation from the forum state will not justify jurisdiction if they do not stem from a constitutionally cognizable contact with the state, quoting again from Kulko. In our view, whatever marginal revenues petitioners may receive by virtue of the fact that they produce, or that their products rather, are capable of being used in Oklahoma is far too attenuated a contact to justify the state's exercise of infrasum jurisdiction over them. Because we find that petitioners have no contacts, ties, or relations with the state of Oklahoma, the judgment of the Supreme Court of Oklahoma is reversed. Oklahoma Supreme Court, you wrong. Takes me back to civil procedure, the first semester of law school. Oh, those were the days. All right. So now we got that Kulko case now. It's another long one. All right. So happy St. Patrick's Day, everybody. Raise a pint. Raise a pint to old St. Pat, by God. All right. So this is the Kulko versus Supreme Court case that the case in Volkswagen was citing, right? Over a Kulko, right? Right. This is a 1978 case. So Volkswagen happened in 1986, in 1980, if memory serves. Yeah, 80. So this was 2 years before Volkswagen. So that's why it cites it. Okay, so Justice Marshall, who was not on the court when Justice White gave his decision in the Volkswagen case, Justice Marshall had gone then. This is Justice Marshall's opinion, in the court in 1978. Appellant Araza Kulko and appellee Sharon Kulko Horn were New York domiciliaries when they got married during a brief stay in California. They returned to New York with their 2 children, Darwin and Elsa, and they were born there. The 2 children, the 2 children were born in New York. The couple and their 2 children resided in New York until they were separated in 1972. Sharon and the children moved to California. Sharon returned briefly to New York to sign a separation agreement specifying that Ezra. Ezra's the dude. Ezra, not Araza. Ezra's the guy. And Ezra would pay alimony, and the children would remain with Ezra during the school year and visit Sharon in California on holidays. Immediately after execution of the separation agreement, Sheridan flew to Haiti, where she secured a Haitian divorce decree that incorporated the terms of the separation agreement. Subsequently, each of the children expressed their desire to live with their mother in California. Ezra agreed and purchased a one-way plane ticket for Elsa and later paid for Darwin's move as well. Once both children arrived, Sharon instituted a civil action in California to establish the Haitian divorce as a California judgment, to modify the judgment so as to award her full custody of all children, and to increase the appellant's, which is Ezra's, child support obligations. Ezra was served with process under the California long-arm statute that allows the state court to assert jurisdiction on any basis not inconsistent with the Constitution. He challenged the court's jurisdiction under the Due Process Clause. The California Supreme Court rejected his argument and held that jurisdiction was proper because the appellant had a cause and effect that happened in California by purposely sending his child to the state. In reaching its result, the California Supreme Court did not rely on appellant's glance and presence in the state some 13 years before the events that led to the controversy, nor could it have. Appellant has been in California only 2 occasions, once in 1959 for a 3-day military stopover on his way to Korea, and again in 1960 on a 24-hour stopover on his return from Korean military service. To hold such temporary visits to a state as the basis for the assertion of in personam jurisdiction over unrelated actions arising in the future would make a mockery of the limitations on state jurisdiction imposed by the 14th Amendment. Finally, somebody says, fuck you, California. Took about fucking 400 pages of this book for somebody to finally do it. Nor did the California court rely on the fact that appellant was actually married in California in one of his 2 brief visits. We agree that where 2 New York domiciliaries, for reasons of convenience, marry in the state of California and therefore spend their entire married life in New York, the fact of their California marriage by itself cannot support a California court's exercise of jurisdiction over a spouse who remains a New York resident in an action relating to child support. Finally, in holding that personal jurisdiction existed, the court below carefully disclaimed reliance on the fact that appellant had agreed at the time of separation to allow his children to live with their mother 3 months out of the year, and that he had sent them to California each year pursuant to this agreement. To find personal jurisdiction in the state on this basis merely because the mother was residing there would discourage parents from entering into any reasonable visitation agreements whatsoever. Moreover, it could arbitrarily subject one parent to suit in any state of the union where the other parent chose to spend time while having custody of their offspring pursuant to a separation agreement. As we have emphasized, quote, the unilateral activity of those who claim some relationship with a non-resident defendant cannot satisfy the requirement of contact with the forum state. It's essential in each case that there be some act by which the defendant purposefully avails him or herself of the privilege of conducting activities within the forum state. The purposeful act that the California Supreme Court believed did warrant the exercise of their jurisdiction over the appellant in California was his actively and fully consenting to send Elsa living in California for the school year, and that the appellant's acquiescence to Elsa's desire to live with her mother conferred jurisdiction over him, the appellant, in the California courts of this action. A father who agrees it is in the interest of family harmony and his children's preferences to allow them to spend more time in California than was required under separation agreement can hardly be said to have purposely availed himself of the benefits and protections of California law. Nor can we agree with the assertion of the court below that the exercise of the in personam jurisdiction here was warranted by the financial benefit the applicant derived from his daughter's presence in California for 9 months out of the year. This argument rests on the premise that, while the appellant's liabilities for support payments remain unchanged, his daily expenses for supporting a child in New York decreased. But this circumstance, even if it is true, which we don't think it is, does not support California's assertion of jurisdiction here. Any diminution of appellant's household costs resulted not from the child's presence in California, but rather from its absence in New York. 3. In seeking to justify the burden that would be imposed on appellant were the exercise of in personam jurisdiction in California sustained, the appellant argues that California has substantial interest in protecting the welfare of its minor residents and promoting the fullest extent possible a healthy and supportive family environment in which the children of the state are to be raised. These interests are unquestionably important, but while the presence of the children and one parent in California arguably might favor application of California law in a lawsuit in New York, the fact that California might be the center of gravity for choice of law purposes does not mean that California has personal jurisdiction over a defendant. And California has not attempted to assert any particularized interest in trying such cases by its courts, e.g. by enacting a special jurisdictional statute. California's legitimate interest in ensuring the support of children residents in California without unduly disrupting children's lives, moreover, is already being served by the state's participation in the Uniform Reciprocal Enforcement and Support Act of 1968. The statute provides a mechanism for communication between court systems in different states in order to facilitate the procurement and enforcement of child support decrees where the dependent children reside in a state that cannot obtain personal jurisdiction over a defendant. It cannot be disputed that California has substantial interest in protecting resident children and in facilitating child support obligation and actions on behalf of those children, but these interests simply do not make California a fair forum in which to require the appellant, who derives no personal and no commercial benefit from his child's presence in California and who lacks any other relevant benefit conflict with the state, either to defend a child support suit or to suffer liability by default from not being there. Accordingly, we conclude that the appellant's motion to quash service on the grounds of lack of personal jurisdiction was erroneously denied by the California courts. The judgment of the California Supreme Court is therefore and hereby reversed. And Brennan and White and Powell dissented, and they don't even include that because fuck those guys, apparently. Two down, want to go. All right. Our third case today is Walden versus Fiore. It's a 2014 case. Bye, other viewer who was here for a second. Hope you come back. I don't really care. All right. Walden versus Fiore, 2014 case. It's long as shit, too. All right. Justice Clarence Thomas delivers the opinion of the court, and it was unanimous, so 9 justices all for this opinion. All right. Ugh. Sleepy. This case asks us to decide whether a court in Nevada may exercise personal jurisdiction over a defendant on the basis that he knew his allegedly tortious conduct in Georgia would delay the return of funds to plaintiff with connections to Nevada. Because the defendant had no contact with Nevada, and because a plaintiff's contact with the state in the forum state cannot be decisive in determining whether a plaintiff's or whether a defendant's due process rights are violated, we hold the court in Nevada cannot exercise personal jurisdiction over the defendant under these circumstances. Petitioner Anthony Walden serves as a police officer for the city of Covington, Georgia. I've been there. In August 2006, Petitioner was working for the Atlanta Hartsfield-Jackson Airport. I've been there. As a deputized agent of the Drug Enforcement Agency, DEA. As part of a task force, Petitioner conducted investigative stops and other law enforcement functions in support of the DEA's Airport Drug Interdiction Program. On August 8th of 06, Transportation Security Administration agents searched respondents Gianna Fiore and Keith Gibson and their carry-on bags at the San Juan Airport in Puerto Rico. They found $97,000 in cash. Fiore explained to DEA agents in San Juan that she and Gibson had been gambling at a casino known as the El San Juan, and they had residences both in California and Nevada, though they provided only California IDs. After respondents were cleared for departure, a law enforcement official at the San Juan airport notified the petitioner's task force in Atlanta that respondents had boarded a plane for Atlanta where they planned to catch a connecting flight to Las Vegas, Nevada. When respondents arrived in Atlanta, petitioner and another DEA agent approached them at the departure gate for their flight to Las Vegas. In response to petitioner's questioning, Fiore explained that she and Gibson were professional gamblers. Respondents maintained that the cash they were carrying was their gambling bank and their winnings. After using a drug-sniffing dog to perform a sniff test, the petitioners seized the cash. Petitioner advised the respondents that their funds would be returned if they later provided a legitimate source for the cash. Respondents then boarded their plane. After the respondents departed, petitioner moved the cash to a secure location, and the matter was forwarded to DEA headquarters. The next day, petitioner received a phone call from respondent's attorney in Nevada seeking the return of the funds. On 2 occasions over the next month, petitioner also received documentation from the attorney regarding how these funds were legitimate. At some point after petitioner seized the cash, he helped draft an affidavit to show probable cause for the forfeiture of the funds and forwarded the affidavit to the United States Attorney Office in Georgia. According to the respondents, the affidavit was false and misleading because the petitioner misrepresented the encounter at the airport and omitted the exculpatory information regarding the lack of any drug evidence and any legitimate source of the funding. In the end, no forfeiture complaint was filed, and the DEA returned the funds to the respondents in March of 2007. Respondents filed suit against petitioner in the United States District Court for the District of Nevada seeking money damages under Bivens versus 6 unknown Fed narcotics agents. Respondents alleged that petitioner violated their Fourth Amendment rights, which he fucking did, by seizing the cash without probable cause, 2, by keeping the money after concluding it did not come from drug-related activity, and 3, by forwarding a probable cause affidavit to support a forfeiture action while knowing the affidavit contained false statements, and 4, by willfully seeking forfeiture while withholding exculpatory information, and 5, by holding that exculpatory information from the United States Attorney's offices. 2. The case addresses the minimum context necessary to create specific jurisdiction. The inquiry whether a forum state may assert specific jurisdiction over a non-resident defendant focuses on the relationship among the defendant, the forum, and the litigation. For a state to exercise jurisdiction consistent with due process, the defendant's suit-related conduct must create a substantial connection with a forum state. 2 related aspects of this necessary relationship are relevant to this case. First, the relationship must arise out of contacts that the defendant himself creates with the forum state, quoting from Burger King Corporation versus Rudezowick. Due process limits on the state's adjudicative authority principally protect the liberty of non-resident defendants, not the convenience of plaintiffs or third parties, quoting Worldwide Volkswagen. We have consistently rejected attempts to satisfy the defendant-focused minimum context inquiry by demonstrating context between the plaintiff or a third party and the forum state. The unilateral activity of another party or a third person is not appropriate consideration when determining whether the defendant has sufficient context of the forum state to justify the assertion of jurisdiction. We have thus rejected a plaintiff's argument that a Florida court could exercise personal jurisdiction over a trustee in Delaware based solely on the contacts of the trustee's settler, who is domiciled in Florida and who executed powers of appointment there. We have likewise held that Oklahoma courts cannot exercise personal jurisdiction over an automobile distributor that supplies to New York, New Jersey, and Connecticut dealers based only on the automobile's purchaser's act of driving it to Oklahoma highways. Volkswagen Corp, citing what we already read. Put simply, however significant the plaintiff's contacts with the forum may be, those contacts cannot be decisive in determining whether the defendant's due process rights may or may not be violated. Second, our minimum context analysis looks to the defendant's contacts with the forum state itself and not the defendant's contacts with persons who reside there. However, minimum the burden of defending in a foreign tribunal, a defendant may not be called upon to do so unless he has the minimal contacts with that state, which are a prerequisite to the exercise of its judicial power over him. Accordingly, we have upheld the assertion that the jurisdiction over defendants who have purposefully reached out beyond their state and into another state by, for example, entering a contractual relationship that envisioned continuing and wide-reaching contacts in the forum, which is quoting the Burger King case, or by circulating magazines, which is quoting the Hustler case. And although physical presence in a forum state is not a prerequisite to jurisdiction, a physical entry into the state, either by the defendant or by a person through an agent, goods, mail, or some other means of marketing or advertising, is certainly a relevant contact. But the plaintiff cannot be the only link between the defendant and the forum. Rather, it is the defendant's conduct that must be the necessary connection with this forum state. That is the basis for the jurisdiction over him. If the question is whether an individual's contact with an out-of-state party alone can automatically establish sufficient minimum contacts in the other party's home forum, we believe the answer is clearly that it cannot. To be sure, a defendant's contacts with a forum state may be intertwined with his transactions or interrelations and interactions with the plaintiffs or other parties, but a defendant's relationship with a plaintiff or a third party standing alone is not a sufficient base for jurisdiction. Due process requires that a defendant be hailed into court in a forum state based upon its own affiliation with the state and not based upon any random, fortuitous, or attenuated contacts he makes by interacting with other people who are affiliated with or domiciled in that other state. The same principles apply when intentional torts are involved. In the context, it is likewise insufficient to rely on defendant's random, fortuitous, or attenuating contacts or the unilateral activity of a plaintiff. A forum state's exercise jurisdiction over an out-of-state or intentional tortfeasor may be based upon intentional conduct by the defendant and that creates the necessary contacts with the forum. For example, a California actress brought a libel suit in a California state court against a reporter and an editor, both of whom work for the National Enquirer and its headquarters in Florida. The plaintiff's libel claims are based on an article written and edited by the defendants in Florida, with publication by the National Enquirer, which is a national weekly newspaper that has a California circulation of over 600,000 recipients. We held that California's assertion of jurisdiction over defendants was consistent with due process, although we recognize that defendants' activities focused on the plaintiffs are jurisdictional inquiries focused on the relationship among the defendants, the forum, and the litigation. Specifically, we examined the various contacts the defendants had created with California by writing the allegedly libelous story and selling the fucking paper in California. We found those forum contacts to be ample. The defendants relied on phone calls to California sources for the information that was in their article. They wrote the story about the plaintiff's activities in California. They caused reputational injury in California by writing an allegedly libelous article that was widely circulated in California. And the brunt of the inquiry was suffered by the plaintiff in California. In sum, California was the focal point of both the story and the harm suffered. Jurisdiction over the defendants was therefore proper in California based upon the effects of their Florida conduct in California. The crux of this case was that the reputation-based effects of the alleged libel connected the defendants to California, not just to the plaintiff. The strength of that connection was largely a function of the nature of the libel tort. However, if communicated to and read and understood by third persons, see respondents' action in that case, reputation is the estimation of which one's character is held by neighbors and by associates. Accordingly, the reputational injury caused by the defendant's story would not have occurred but for the fact that the defendants wrote the article for publication in California that was read by a large amount of California residents. Indeed, because the publication of third persons is a necessary element of libel, the defendant's intentional tort actually occurred in California. Quote, the tort of libel is generally held to occur while the offending material is circulated. In this way, the effects caused by the defendant's article, i.e. the injury to the plaintiff's reputation, the estimation of California public, connected the defendant's conduct to California, not just the plaintiffs who lived there. This connection, combined with the other various facts that gave the article a California focus, sufficed to authorize the California court to exercise its jurisdiction in that case. 3. Applying the foregoing principles, we conclude that petitioner lacks the minimum contacts with Nevada that are a prerequisite to exercise the jurisdiction over him. It is undisputed that no part of petitioner's course of conduct occurred in Nevada. Petitioner was approached, questioned, and searched and seized cash at issue in the Atlanta airport. It is alleged that petitioner later helped draft a false probable cause affidavit in Georgia and forwarded that affidavit to a United States Attorney's Office in Georgia to support a potential action for the forfeiture of the civil assets which were seized. And petitioner never traveled to, nor conducted any activities within, nor contacted anyone within, or sent anything to, or received anything from Nevada. In short, when viewed through the proper lens, where the defendant's actions connect him with the forum, petitioner formally formed no jurisdiction relevant to Nevada contacts. As previously noted, Calder made clear that the injury from a forum resident is not sufficient connection with the forum. Regardless of where a plaintiff lives or works, an injury is jurisdictionally relevant only insofar as it shows that the defendant has formed a contact with that forum state. The proper question is not whether the plaintiff experienced an injury or an effect, but whether the defendant's conduct connects him with the forum state in any meaningful way. Respondents claim that injury does not evince a connection between petitioner and Nevada. Even if we consider the continuation of the seizure in Georgia to be a distinct injury, it is not the sort of injury that is tethered to Nevada in any meaningful way, because even though the plaintiffs lacked access to their funds in Nevada, nor because anything independently occurred there, but because Nevada is where they chose to be at the time they wanted to use those funds that were secured and seized by the petitioner. Respondents would have experienced the same lack of access in California, Mississippi, or Mars, or wherever else they might have traveled and found themselves wanting of the money that had been taken from them. Unlike the broad publication of the forum-focused story of Calder, the effects petitioner conduct on response are not connected to the forum state in any way that makes those effects a proper basis for said jurisdiction. Now, a new part. Well-established principles of personal jurisdiction are sufficient to decide this case. The proper focus of the minimum context inquiry in the intentional torts cases is the relationship among the defendant, the forum, and the litigation. And it is the defendant, not the plaintiff or third parties, who must create the contacts with the forum state. In this case, the application of these principles is clear. Petitioner's relevant conduct occurred entirely in Georgia, and the mere fact that his conduct affected the plaintiffs with connections to the forum state of Nevada do not suffice to authorize a Nevada jurisdiction. We therefore reverse the judgment of the Court of Appeals. It is so ordered. And there you go, folks. 42 minutes in. Happy St. Patty's Day, y'all. God bless you all. Love you all. God bless and good night.